as regards the publication of the defamatory content allegedly contained in the writ petition, my lords. I will first advance my legal submissions and thereafter I'll proceed to substantiate it from the paperwork as regards the factual submissions. My lord, first and foremost, the prayer before this honorable court is to adjudicate upon the defamatory nature of the content of the writ petition. And in order to grant injunction against...
You're answering the application, is it?
Yes, ma'am. That's
Expunging,
the only issue.
deleting of
My lord, there are
on that.
two applications are there. First one filed on 24th of April 2024, whereby injunction from the contents being published.
That's what. That's one thing. Yes.
So I'm first responding to that.
Yes.
Later on, submissions will be similar for the other one. My lord, at the very outset, it is submitted that on the previous occasion of hearing, this honorable court was told that there is an injunction order of the trial court subsisting as regards the injunction with regard to the
Publication.
content of the present petition. My lord, the first and foremost submission is that content which is covered by the order of the trial court was different from the allegations leveled against the respondent advocates in the present petition. In the present petition, there are allegations of bribery, bench fixing, engaging in corrupt practices in order to influence not just the trial court proceedings, but also the high court proceedings. As regards that injunction order was granted by the court on the specific contention of the plaintiff, who is respondent number 3 herein, that there is some sexually explicit content in possession of some private respondents who are associated with petitioners, which may go public to cause disrepute to the plaintiff, respondent number 3 herein, and to his family. Well, based on that submission, an ex parte ad interim order was granted in the absence of the present petitioner. Subsequent to which, we appeared on the very next date of hearing before the trial court. We filed our written submissions, also opposed the grant of the ad interim injunction, and requested the trial court to hear the matter on merits and decide the temporary injunction application. On 18th of June 2023, we also filed an application seeking vacation of the ex parte ad interim order, which remains pending before the trial court even today, my lord, despite being the ad interim order. On 7th of August 2023, the trial court extends that order of ad interim injunction till further orders, making it operative for...
Without considering the application.
Nothing, my lord. Nothing was considered. And it was specifically recorded by the trial court that there is a strong opposition from all the contesting defendants in the matter. My lord, however, that order has no bearing, in my respectful submission, that order has no bearing in the present case because it relates to different content. And in order to adjudicate this present application and to grant the relief claimed therein, my lords will have to hear the matter on merits and adjudicate it in light of the submissions which I am advancing. My lord, the law says that in order to grant injunction as regards the defamatory content, first and foremost, the presumption will be in favor of free speech. So the burden lies on them to prove that whatever I'm saying, whatever is the allegation in the writ petition is untrue. In order to have a fair play and to prima facie establish my case, I am in possession of certain audio recordings which contains categorical admissions by none other than the respondent advocates, respondent number 2 and 3, who happens to be wife and son of former High Court Judge, Mr. B.S. Patil, and present Lokayukta of the state, wherein they categorically admit that number 1, they bribed the trial court judge using the influence of Mr. B.S. Patil as former High Court Judge. Number 2,
Lord,
that...
I object to this kind of a insinuation.
This is wrong.
What will
You're in a court of law. You just address as respondents or whatever it is, and you're straight away making allegations.
My lord, we have proof. My lord,
That's not correct. You make your submission.
My lord,
You need not submit to the gallery. You just make your submission. That's
my lord, I'll refer as third person.
Yes.
So there is allegation that they were engaged in this kind of corrupt practices. They bribed the trial court judge, extorted money from the petitioners, saying that we have influence of the judiciary, we will manage your orders. Secondly, there is
But on the bar council matter, you are arguing something else.
My lord, I am arguing something else because the issue has already, my main prayer has already been adjudicated upon. That is no more a list before your lordship.
Which one?
The main order of
I have not yet passed the final order. It's only an interim order.
Very good, my lord. My lord, I had already observed that I'll have to go for revision. So I'm not on that, my lord.
So you're only on the application, right?
My lord, that's...
Submit on the application.
My lord. My lord, the law says the presumption will be in favor of free speech. in order to displace that presumption, they will have to establish that whatever I'm submitting, whatever is the allegation is false. Number two, my lords, it says that there cannot be a blanket order without analysis of the defamatory content as regards the injunction with regard to defamatory content. And the freedom of speech cannot be curtailed lightly because it will also injunction against such
You concentrate on that.
publication will also hamper.
Your free speech is curtailed
Free
is a
speech.
submission. So concentrate on that.
Madam, my free speech, right of press to report freely,
Hmm.
and the
So
right to know
now,
people
should I
at large.
presume that you're interested only in reporting it to the press and nothing else?
My lords, my submission is, my respectful submission is only this. Whether I am interested in going public with the
No,
allegations.
no, you're
of-
saying I should not be curtailed to report this to the
Well,
press.
that should be left to the choice of the petitioner, whether they want to go public with this or not.
That's all.
So far, they have not gone. And they never chose to. But this should not be their compulsion. That liberty should not be curtailed by any
That
judicial.
you tell me, I will answer.
Yes, ma'am. So my submission is this. Number two, my lord, this order of injunction will also curtail the right of the freedom of press to report freely and the right of the people at large to know, right to know. And my lord, my respectful submission is also this, that this IA is a strategic litigation intended to debar public participation in the affairs of the judiciary because it involves allegations as regards the presiding judges of this court as well as the trial court, my lord. Well, I'm placing heavy reliance on the judgment of the apex court in Bloomberg Television Production Services Limited,
Give
Private
that.
Limited versus Z Entertainment Enterprises Limited.
Give that.
Reported. My lord, the relevant para 5.
Where is the judgment?
No.
If you hold it and say relevant para 5, where do I
That's
read?
quoted in my response also.
That's all right. Where is the judgment?
Supplied.
Give a copy of the judgment and then read it. What all you want to rely, please give. Bloomberg Television. Paragraph, madam?
Paragraph 5. my lord.
5.
The threefold test of establishing a prima facie case, balance of convenience, and irreparable loss or harm for the grant of interim injunction is well established in the jurisprudence of this court. This test is equally applicable to the grant of interim injunctions in the defamation suits. However, this threefold test must not be applied mechanically to the detriment of other party and in case of injunctions against journalistic pieces, often to the detriment of the public. While granting interim relief, the court must provide detailed reasons and analyze how the threefold test is satisfied. A cursory reproduction of the submissions and precedents before this court is not sufficient. The court must explain how the test is satisfied and how the precedents cited apply to the facts of the case. This is one paragraph. The other judgment which I am relying upon is Bonnard versus Perryman, my lord. The landmark judgment on of the Chancery Division.
Page. Because you don't have paragraphs. Page.
My lords, may kindly peruse page number 9 of my objection, statement of objections. Somehow the paragraph is missed.
Which statement of objection?
A statement of objections filed on 31st of May 2024.
According. 30th of May. Paragraph, madam?
Page number 9.
You have quoted all the judgments here, is it?
My
What
lords,
all you are relying?
yes, ma'am. My lord, it says, but it is,
I thought you're saying only one you have quoted.
sorry, my lords.
No, I thought you said only one you have quoted. If you have quoted all, no problem. Then don't give a copy.
My lords, I have quoted.
Those paragraphs, if you're relying on, don't give a copy.
My lords, whatever I'm relying upon, I have already
Ah.
quoted. My lords.
Yes,
But it is obvious that the subject matter of an action for defamation is so special as to require exceptional caution in exercising the jurisdiction to interfere by injunction before the trial of an action to prevent an anticipated wrong. The right of free speech is one which it is for the public interest that individuals should possess, and indeed that they should exercise without impediment, so long as no wrongful act is done. And unless an alleged libel is untrue, there is no wrong committed. My lords, I emphasize on the word, on the statement that there is no wrong committed. Unless an alleged libel is untrue, there is no wrong committed. But on the contrary, often a very wholesome act is performed in the publication and repetition of an alleged libel. Until it is clear that alleged libel is untrue, it is not clear that any right at all has been infringed. And the importance of leaving free speech unfettered is a strong reason in cases of libel for dealing most cautiously and fairly with the granting of interim injunction. Emphasis supplied. The other judgment which I am relying upon is the next quoted for my lords, Fraser versus Evans. Insofar as the article will be defamatory of Mr. Fraser, it is clear he cannot get an injunction. The court will not restrain the publication of an article, even though it is defamatory. When the defendant says he intends to justify it or to make fair comment on a matter of public interest that has been established for many years ever since Bernard versus Ferryman, the reason sometimes given is that defense of justification and fair comment are for the jury, which is constitutional tribunal and not for a judge. But a better reason is the importance in the public interest that the truth should out.
No, all
My
this would be helpful to you in a challenge that you have made to the order of injunction.
My lord,
In this case,
My
which
lord,
is that you have challenged, which is the writ petition?
my lords, I have a copy. My lord, it's WP number 14486 of 2024.
Shall we have them together?
My lord,
The grounds are same in entirety, my lord.
that may not have any bearing, my lord, on this. That's
No,
what they have
as
also-
far as revision is concerned, I will close it.
Huh.
Because he is also agreeable for that. But if I have to answer these things,
My lord,
he has
we'll look at
challenged
it.
that.
I'll tell you, lordships, 1 minute. Dehors, my lord, the injunction order granted by the trial court. If, my lord, they make allegations, my lord, with an intention to, my lord, which are not, my lord, germane to the facts of the case, and, my lord, with an intention to, my lord, go to the press. Your lordship, my lord, the judgment
No,
also.
that I have said,
Correct. Your
that I have
lordships have
already
already stated.
protected. When there is a challenge to that, we will hear
Yes.
them together.
Yes.
Number, give me that number, madam.
Yes. 14486 of 2024, WP.
Since this is parted already.
All right. I mean, your lordship, I have no problem at all. I don't choose judges. I'm agreeable. Only thing is, it will go on and on like this. That's all that I was.
No, but that.
Very well, very well, madam.
Because
No
all the
problem.
grounds that
Anytime.
you are now saying
Anytime.
is.
Same.
Anytime subject, your
That-
lordship.
Clarity
I'm always
and-
happy to be here.
Same here, my lord.
Seriously? Yes.
Yes, ma'am.
Yes. Number. Which is that number? Where is that number?
My lord.
4486. Work on that.
14486 of 2024, I believe.
Madam.
Writ petition. But other objections ಹಾಕಿದ್ದೀರಾ? ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅಂತ ನೋಟಿಸ್ ತಗೋತೀವಿ.
ತೊಂದ್ರೆ ಇಲ್ಲ ಎಲ್ಲ ಇಲ್ಲಿ we will do whatever is to be done.
Yes,
Let
definitely.
it get listed.
Very well, very well.
Then we'll do it.
Please, madam.
Tag this petition along with. The learned counsel appearing for the petitioner submits that the petitioner has no objection for for filing a revision petition before the Bar Council of India in terms of section 48A of the Advocates Act. The learned counsel would but submit that there is an application, there are two applications pending which would curtail her freedom of speech, who is the petition- their freedom of speech.
And the
learned
right to go
counsel
to
would say-
press.
Huh?
And the right to go to press.
And people's
and the
right to
right
know.
and the right to go to press.
My lord,
Uh,
people's right to know also.
So it's lie, everything I should say now only, what is this? Yes, I'm just tagging it. So,
Please.
Sorry.
so and so. The learned counsel would submit that the order of injunction that is operating before the concerned court, has been called in question before this court in writ petition.
14486 of 2024.
So and so. They, in the light of the issue arising out of the same proceeding, attack this petition along with so and so and list them. When do you want? When are you coming back again?
Yes, my lord. My lords, I'm coming back on 25th. So, my
Oh.
lords may kindly have it on 26th or 27th.
we'll take it on 27th.
Very
Yes. List the matter on 27th at 2:30 PM
Deeply
for the hearing.
grateful, Your Lordship.
Interim order to be extended.
Interim order subsisting shall continue till the next day.
Grateful.
Okay.
Other hearing, then I have-